Okay, I need a motion from council to hear Mr. Riley.
So moved.
Moved and second for have Mr. Riley speak. Discussion?
Question.
Question on the motion. All in favor signify by saying aye.
Aye.
Opposed, nay. Please proceed.
Thank you, Mr. President. Briefly to council.
You guys.
Attorney Pat Riley, 520 Broadway, Lorraine, Ohio, here on behalf of the Elyria Firefighters Local 474. I'm going to offer just two brief observations from our legal standpoint. I'm not here in any way to suggest that I am right in all regards about these matters as I will describe them to you, and I'm not suggesting that these are being offered in the nature of a threat of litigation, simply a matter of education from our standpoint. In Ohio, the relationship between a public employer and a public employee group is governed by written law. That written law is codified in Chapter 4117 of the Ohio Revised Code. And that law essentially is the law of collective bargaining. That law was passed in 1984. And at that time, it contained a very important provision, a provision that bears upon your right to take the action that you're considering tonight. And that is the recognition of a union and how it is that that union will be structured, known to lawyers as the composition of a bargaining unit. Earlier today, I had the opportunity to speak with the state agency that governs the collective bargaining process in Ohio. That state agency is known as the State Employment Relations Board, or SERB for short. I spoke with the chief officer in their representation unit, and it's the representation unit that deals with issues such as bargaining unit composition. I called them because I wanted to get confirmation that my concerns about this prospective action by council could be unlawful. My concerns are that you don't have the authority to change the composition of the Elyria Fire Department unilaterally. That has to be done in accordance with law, and that law requires either a mutual and joint agreement to do so, or a bargaining again of that composition. She indicated to me, in fact, that she felt I was right about that it could not be done unilaterally by the employer or by giving the administration the right to do it through the administration. You cannot change the composition of this firefighter unit. You cannot change the number of ranked officers. You cannot change the number of men. You would have to petition SERB and seek either our consent or SERB's approval before you could do that. So point of order number one is I would ask you to consider the fact that the passage of this ordinance would not be lawful under Ohio's Collective Bargaining Act and would therefore create concerns on our part that we would have to face and deal with. Now the second point I think that is important legally is that this ordinance, if passed, in my opinion, if passed, would be unlawful, but if passed, could result in demotions. Now that's not council's decision to make, that's your administration's decision to make. But if in fact they attempt to implement the reduced ranked number of officers, they would effectively be creating or doing demotions within the fire department. In Ohio, the Ohio Civil Service Law governs when it is that an employer has the right to make a demotion. And I'm telling you, from my opinion, humbly, that you cannot demote public employees for financial reasons. The law does not permit that. In Ohio, the Civil Service Law only permits demotions for cause. And the causes that are set forth in the statute are essentially wrongdoing or misdeeds by your employees. They have to be guilty of malfeasance, misfeasance, nonfeasance, or other things that would be and essentially would warrant discipline. If in fact you pass this ordinance, and if in fact the administration attempts to demote by reducing the numbers in each rank or by kicking men backwards, in my opinion, men and women, in my opinion, that would be unlawful. The court does not allow that to happen. In fact, when I spoke to the representative of SERB about this issue of changing the composition of a fire department by unilateral councilmanic action, she indicated to me that she thought this action could be a first shot across the bow by public employers in terms of the circumstances that they have been presented with recently as a result of financial difficulties that they face. I'm not here to minimize that problem, but I'm here rather to point out that there's a proper process for going about what you're attempting to do, and the passage of an ordinance restructuring your unit is not the proper process. In fact, she told me that because of my call this morning, they were going to put serve on a status known as alert, and that is essentially a process by which they begin to look for these sorts of actions by public employers, and when brought to their attention, take appropriate action. The last thing I want to say to you is this. It is my opinion that the resources of the city, the resources of the union, are better spent on places other than lawyers and professional consultants. If you engage in this process, and if I am right, I'm not suggesting that I am absolutely right, but if I am right about this, the potential consequences will be the expenditure of money by council or perhaps specialists in the area to address these issues, the expenditure of funds by the union for people like me. I think that that's a waste of money. I'm presently engaged as counsel in a fight between the City of Lorraine and the County of Lorraine over a tax abatement program. In that fight, the City of Lorraine has spent hundreds of thousands of dollars on attorneys, as has the county. And those resources, I believe, are not resources that the city and the county have to expend. I suggest to council that there is a better way to go about this process. A better way would be dialogue between the employer and the union, or between their respective representatives, a mutual agreement as the law requires, or, as I understand it, this contract comes up for renegotiation, and this year, at mid-year, a better time to address this would be at the time that this contract is up for renegotiation. I urge you to seek the opinion of your law director about the issues I've raised with you tonight. I ask you to take your time in determining whether or not there's merit to the points that I raised, in the hopes that we can avoid a mistake being made and find a better way to resolve this problem.